Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have some breaking news for you pertinent to an appeal that we have been closely monitoring. The Delphi appeal is styled as Richard Allen, he is the appellant, versus State of Indiana as the appellee. Mr. Allen filed his appeal last year, 2025, seeking one of two remedies. He wants either the convictions of the unalivings of two young friends, Abby and Libby, that he was found guilty of following a jury trial with Judge Frances Gull presiding, thrown out. In the alternative, he is looking for the appellate court to order the court below to proceed with a Franks hearing that Mr. Allen requested and Judge Gull denied. Now, what is this? A Franks hearing is called that because of a famous Supreme Court of the United States case known as Jerome Franks versus State of Delaware, and it stands for the proposition where a defendant proffers sufficient evidence relative to the impropriety of a warrant affidavit that led to, for instance, an arrest or a search and seizure violative of the Fourth Amendment to the United States Constitution, that the trial court should proceed with a full-blown evidentiary hearing on the matter and determine whether that warrant should be thrown out and anything seized thereafter deemed fruit of the poisonous tree. The briefings were filed. The state of Indiana has very aggressively denied any wrongdoing, urging the appellate panel to affirm everything that happened in the lower tribunal. Mr. Allen, in April of 2026, as we previously reported, filed a motion for oral argument. What is this? A motion is an application or a request for a court order. Here, the motion is directed toward the appellate panel, seeking a hearing before the appellate panel rules ultimately on the merits as to whether relief should be granted or not granted to Mr. Allen. Oral argument is not certain. Sometimes the other side will oppose it. What Mr. Allen stated in the motion is that oral argument is proper, that the parties should be given an opportunity to come before the appellate court rules on the papers and pitch their reasons why their position is correct. Then the appellate panel would rule. We've been checking the docket to see if there was any response from the state of Indiana, and there was none. Then today, the 14th of May, 2026, came an order issued by the Indiana Appellate Court saying yes to Mr. Allen's motion for oral argument. The order is on our YouTube channel. The link is in the description to this podcast episode. Oral argument is set for September 21st. It will be in Indianapolis. It will be live streamed so the public can watch the proceedings if they're not able to go to and to get a seat live at oral argument. Once the two sides, and they've been given 30 minutes per side, make their pitch to the three-judge appellate panel, there is the potential that based on the questions that the appellate panel asks or comments that they make, that nuggets of information might be gleaned as to how they're leaning in terms of an ultimate ruling. Now, once that oral argument on September 21st concludes, then there will be a ruling that will come out weeks, sometimes months, following oral argument. Because Judge Frances Gull announced her retirement from the bench some time ago, effective December 31st, 2026, this development in oral argument that won't happen until near the end of September, and then a ruling that will follow it, making it less and less likely that Judge Gull would be the presiding judge if the appellate panel rules in favor of Mr. Allen, in either reversal with a new trial if that happens, or ordering the Franks hearing. Please stay tuned to the Indie Zone for further updates. Until next time, this is Kathy. Thank you for joining us here today.